Hi, Assalamualaikum and good morning to my Dr. Sabri bin Muhammad Sharif. So today we are from Group 5. We'll present about NEMO that QUOD non-habit. So this is our group members. We got 7 members: Mujiayi, Song Waimun, Chin Wailam, Lim Waimin, Khairul Arsyad bin Mughaizi, Faris bin Huda Sunmi and Ahmad Zaim bin Zahran. Okay, we go to introduction. NEMO that QUOD non-habit. This fundamental principle of property law dictates that only the rightful owner can transfer ownership to another. It's a cornerstone of legal system worldwide, designed to prevent fraud and protect property rights. Without this principle, the security of property ownership will be severely undermined. Next, we go to Sale of Acta 1957. This Acta incorporates the NEMO that principle explicitly, stating that a seller must have legal ownership to transfer valid title to a buyer. They ensure that buyer receive clear, unencumbered ownership of the goods they purchase. Next is protection for buyers. While the Acta aims to prevent fraudulent transactions, it acknowledges that buyers often act in good faith, unaware of any defect in the seller titles. Next is exception to the rule. Recognition the potential for unfairness. The Acta includes exception to the NEMO that rule. The exception allowed for the transfer of title in specific circumstances. Last is importance of understanding. Understanding the NEMO that principle and its exception is crucial for anyone involved in commercial transaction. Consumer needs the knowledge to protect themselves from fraudulent sellers, while business need it to ensure the legality of the sale and to avoid legal disputes. Okay, I will pass to the next presenter. Thank you.
Now I would like to present the part of explanation of rule about the principle of NEMO quod non habet. The meaning of this rule is no one can give what they do not have. It's a crucial rule that protects the rights of true owners by preventing unauthorized sales. It ensures that someone who is not the legal owner or does not have permission cannot pass ownership to another person. This principle is important in maintaining trust and integrity in property law and commercial transactions. However, while the rule protects original owners, it may lead to unfair outcomes for innocent buyers, especially in situations like second-hand markets or online platforms where verifying ownership is difficult. That's why the law includes several well-established exceptions such as sales by mercantile agents, joint owners, or buyers in possession, which help balance fairness and promote confidence in trade. These exceptions do not weaken the core principle but instead reflect the practical needs of the market. They allow good faith buyers to obtain valid title in specific situations, helping to prevent unnecessary disruption in commerce. Basically, the NEMO that rule and its exemptions work together to ensure both protection of ownership and fairness in commercial dealings. Understanding this balance is key for anyone involved in buying or selling goods in today's legal and business environment.
Hello everyone, I'll be presenting the application section for our report on the legal principle NEMO det quod non habet, which is embedded in section 27 of the Sale of Goods Act 1957. So what does section 27 means? The section means that a person who isn't the rightful owner of goods cannot transfer better ownership to a buyer. It protects real owners and ensures trust in business transactions. So a key case example is the case of Lee Nyet Kyong v. Phua Cheng Hu. The buyer in this case bought a car in good faith, but the seller wasn't the true owner. The court ruled the buyer didn't get a valid title. So a real life scenario could be that if you buy a phone from a pop-up stall, and later find out it was stolen. Even if you bought it honestly, Section 27 means the phone must be returned to the real owner. Next is the importance and limitations. So this rule is important to prevent fraud, but the law also gives exceptions like sales by agents or under voidable titles to protect innocent buyers. Still, critics say Malaysia's law needs updates to reflect modern commerce. So in summary, Section 27 protects ownership but must evolve to handle today's digital and globalized market.
Hi, my name is Faris. I will explain the first 4 exceptions to the NEMO that quote non-HABET rule under the Sale of Goods Act 1957. This Latin phrase means no one can give what they do not have, but in certain situations, the law allows a buyer to obtain valid ownership, even from someone who is not the true owner. The first one is sale by a mercantile agent under Section 27, subsection 1, paragraph A. The first exception occurs when a mercantile agent sells goods in the ordinary course of business. If the agent is in position with the owner's concern and the buyer purchases in good faith without knowing the agent lack authority, then the buyer gets a good title. Example, in Fox versus King, the court ruled that a buyer who bought from a dishonest agent still had legal ownership because he acted in good faith. Next, sale by one of joint owners under Section 27, subsection 1, paragraph D. The second exception is when one of several joint owners sells the good. If they are in position with the other owner's permission, the buyer can get good title as long as they act honestly and without knowing about any restrictions. Next, sale under a voidable title under Section 27, subsection 1, paragraph C. The third exception applies when a seller obtains goods under a voidable contract, such as through fraud. If the goods are sold before the contract is rescinded and the buyer purchases in good faith, they will receive good title. Example, in Phillips versus Brooks, a buyer who bought a ring from someone who committed fraud was protected because the fraud was not yet discovered. Last one, seller in position after sale under Section 30, subsection 1. If a seller sells goods but still remains in position and then resells to a second buyer who acts in good faith, the second buyer gets good title. This protects innocent buyers who rely on position as proof of ownership.
I'm Adam, so I will continue to present about the exception. The first exception under Section 32 of the Sale of Goods Act applies when a buyer who has possession of goods with the seller consent, like in hire purchase, resells them to an innocent third party. If that third party buys in good faith and without knowledge of the seller's written title, they get good title. This protects commercial certainty and buyers who rely on possession as proof of ownership. The sixth exception comes from the common law doctrine of the occupant. If the true owner, through words, actions, or silence, creates the impression that someone has the authority to sell, they are legally prevented from delaying it later. The buyer must act in good faith. This prevents injustice when owners contribute to misleading appearance. The seventh exception arises in case of sale under court order by a liquidator or official receiver. Even if the person who held the goods wasn't the rightful owner, the buyer still obtains valid title. This is essential in bankruptcies and ensures secure, reliable liquidation sales. Finally, the eighth exception, non-historical, is the market overrule. It held that goods sold in a legitimate open market gave the buyer good title even if the goods were stolen, unless the buyer suspected something. Through abolish, it shows past efforts to support open market commerce. Together, this exception aims to protect innocent buyers, promote trade reliability, and balance ownership rights with market efficiency.
My name is Mujai. So now I will present about legal enforcement and punishment. The Latin phrase that shown by our topic means that no one can give what they do not have. This principle is central to the law of sale of goods. Essentially, a seller cannot transfer a better title to the goods than they themselves possess. This is codified under Section 27 of the Sale of Goods Act 1957, which aims to protect the property rights of lawful owners. However, the law also recognizes the need to protect innocent third parties, especially buyers who act in good faith without knowledge of any wrongdoing. Therefore, Malaysia's legal system enforces this rule both civilly and criminally to maintain fairness and order in commerce. In civil law, the rightful owner has the right to sue the unauthorized seller to recover the goods or claim the compensation for damage. For instance, if someone unknowingly purchased stolen goods, they are often required to return those goods to the original owner, unless the law applies an exception. This ensures that provision alone does not override legal ownership. On the criminal side, if the sale was induced by fraud, deception, or dishonesty, then it can trigger punishment under the Penal Code. For example, Section 403 and Section 405 to 409 deal with dishonest misappropriation and breach of trust. If a seller knowingly sells the goods that don't belong to them and mislead the buyer, that may amount to fraud under Section 415. The penalties may include imprisonment, fine, or both, that depending on how severe the offence is and the value of goods involved. Apart from the Penal Code, the Trade Description Act 2011 also strengthened enforcement. If a seller falsely claims ownership or mislead consumer regarding the legal status of goods, this can be punished under the Act. It helps reinforce consumer protection and promote business credibility. Despite the general rule, the law does provide exception under Section 29 and 30 of the Sale of Goods Act 1957. This exception allows a good faith buyer to acquire valid ownership in certain situations. For instance, a commercial agent selling in the ordinary course of business or a seller who retains possession of goods may still pass a valid title to a buyer acting in good faith.
My name is Lim Wei Ming, so now I will present about the conclusion part. So the core idea is simple. Only someone who legally owns goods can transfer ownership. Even if a buyer asks in good faith, if the seller lacks legal authority, the transaction is invalid. This ensures protection of true ownership. In business significance, these principles support trust and credibility in business transactions, which is critical given the risk of online shopping, informal marketplace, and complex supply chains. It's a safeguard against fraudulent transfer and unauthorized sales. In limitations and challenges, strict application can lead to unfair results, especially for inconsistent buyers who believe they are purchasing for legitimate sellers. In real-world scenarios, verifying ownership is often impractical, particularly in e-commerce or second-hand sales. In expectation to the rules, to address these concerns, Malaysian laws recognize several exceptions, such as sales by agent, sales under vulnerable contract, extortion, and court-ordered transactions. These exceptions strike a balance between ownership rights and commercial participation. In legal protection and enforcement, legal frameworks like the Trade Description Act 2011 and the Penal Code provide both civil and criminal remedies. This can help to defect fraud and protect consumers. But as common events, especially online exciting law, may fall short. Major terms like sales by education and the gap in buyer-seller knowledge show a clear need to reform and enhance transparency and consumer trust. In conclusion, understanding this principle and its expression is crucial, not just for lawyers and business owners, but for all participants in the market. Upholding ownership rights while promoting fairness and availability is essential in today's global economy. That's all for me. Thank you.